Chapter 46, Escape, Prison Breach and Rescue. Section 668. In general, escape, prison breach and rescue are various modes of liberating a prisoner unlawfully. Escape is accomplished without violence, prison breach by means of violence, and rescue by the aid of a third party, either with or without violence. Section 669. Escape, at common law, is a misdemeanor. As said by Justice Peters, in a case frequently cited, the escape of a person lawfully arrested, by eluding the vigilance of his keepers, before he is put in hold or in prison, is an offense against public justice, and the party himself is punishable by fine and imprisonment. For however strong the natural desire of liberty may be, yet every man is bound to submit himself to the restraints of the law. This offense can be committed by the officer or other person who has the prisoner in custody as well as by the prisoner himself. Where the custodian either negligently or voluntarily allows a prisoner to go under circumstances which do not constitute due course of law, he commits a misdemeanor. To render the custodian criminally liable, however, the prisoner must be lawfully under arrest for a criminal offense. The guilt or innocence of the prisoner, however, is immaterial. Section 670. Prison breach. Under the old common law, prison breach was a felony irrespective of the cause of the imprisonment. As said by Justice Peters, by the ancient common law, prison breaches were felonies, if the party were lawfully imprisoned, for any cause whatever, whether civil or criminal, and whether he were actually within the walls of a prison, or in the stocks, or in the custody of a person who had lawfully arrested him. By an early English statute, and however, prison breaches were made misdemeanors in those cases where the prisoners were under arrest for misdemeanors, and this statute is part of our common law. As stated by Justice Peters, the imprisonment must be lawful. Hence, if the warrant was void and the prisoner uses no more force than is necessary to acquire his liberty, the offence is not committed. It is also essential that there be a breaking, but it is sufficient if only slight. Where the prisoner merely climbs over the prison wall, he is not guilty of prison breach, but if in doing so he causes a loose stone in the wall to fall, he is. In the former case the offence is merely escape. It has been held that a forcible breaking from an officer anywhere constitutes this offence. It seems, however, that this constitutes escape rather than prison breach. The fact that the jail or other place of imprisonment is unhealthy or in a filthy state is no defense to this crime, and, as in the case of escape, the guilt or innocence of the prisoner is also no defense. Section 671. Rescue. Rescue, like prison breach, is a felony or a misdemeanor according to the crime charged against the prisoner. To constitute this offence, the act of the rescuer must result in an actual exit by the prisoner. A mere breaking of the prison is not sufficient. Where the prisoner is unlawfully imprisoned and he breaks out, using no more force than is necessary, and other prisoners escape in consequence, he is not guilty of this offence.